My question is that Save a Patriot has been under attack by the government because they do have a web presence. Irwin Schiff is in jail because he had a web presence. They went after Mr. Bannister because he had a web presence. Sherry Jackson, I think, is another one they went after. So my question, generally speaking, is that I'm glad that you're putting up the website and everything else and trying to launch this attack. But one of my major concern is that even with this and with the truthattack.org, what's to stop them from shutting you down and locking you away until the key rots? That's my concern. And I don't know if you've been thinking about that and how you can try to defend yourself against an attack like that, but I think that's something that people need to think about before they start doing these kind of things. Because you know, as soon as you attack the government, they're going to come at you with all guns blazing. That's my question.
I know that I am dealing with the most powerful and the most dangerous organization in the world. I know I was interviewed by a German news agency back last year, earlier half of the year, and they asked me if I would compare the IRS to the mafia. And I said I didn't think so. I said that it is true that the IRS is an organization, just like the mafia is. And it is true that they are engaging in illegal activity, and just like the mafia is. And it is true that they extort and steal and con and cheat people out of their money, just like, the mafia does. But I said the mafia never, ever, ever scared as many people or stole nearly as much as the Internal Revenue Service has. There are a whole lot more people terrified of the IRS than there are of the mafia. So I am aware of what I'm up against, but I left something out a while ago. In 1975, or 73 rather, I raised my hand and I swore to fight for the law as an attorney. In 1971, I raised my hand and swore to die for it if I had to, as an officer of the United States Army. There is no price that's too great for me to pay. This is bigger than me. It's bigger than all of us. And if you don't have something worth dying for, you don't have something worth living for either. I knew what the tests were. I knew what the risks were when I took this on. And I didn't have any choice. And so you just have to be willing to take whatever the effect is. Now, let me make a point at something on your reference to a web presence. All of these people had shirts on too. All these people were wearing shoes the day they were convicted. I don't think that they were pursued because of their web presence. I think they were pursued because of their message. And that message, regardless of how it's being spread, is they're going to do everything they can. Now, when you get into a situation where you have something other than an organization and you're dealing with a member of the media is a sacred cow. And that's what makes this very important. Is that as soon as this kicks off and goes on the air, it becomes part of the media, just like Fox or CNN. And whenever the government attacks it, the media is going to rally. The media will actually come to defend this. It won't come to defend you and me, but it'll come to defend this because it scares them. And you don't realize that John has been pursued because he not because he has a web presence, but because he's said something he didn't like so much as is the fact that they make the distinction that his speech was commercial. All right. Now, what's the difference between commercial speech on a website, commercial speech on a book, and commercial speech on the New York Times? They're selling newspapers. That's commercial speech. What's the distinction? How long is it going to take the press and the media to realize that whenever they can take them, they can take their rights as well? And they can. Now, here's another thing I wanted to mention before I got out of here, and it's the importance of John's case and the 250 that preceded it, and hopefully the very few that are going to follow it. And that is at risk here. And this I had Jeff Dickstein on a radio program on Republic Broadcasting Network as a guest, and for an hour after him, John Kottmeyer as a very special guest. And the pattern that ran through these two, Jeff Dickstein is defending Bill Benson, who's defending his right to tell the truth. So Jeff Dickstein is also in a 6700. Both of them are trying to get their cases heard. And in both cases, they've both been denied the basic right that underlies all rights. This is a common denominator of all rights. If I have a right to freedom of speech, then I can protect that because they can't take that right without due process, right? If I've got property, they can't take that property without what? Due process. If I've got freedom, they can't take that without what? Due process. In both of these cases, both of the defendants were denied an opportunity to be heard. One of the most basic parts of what makes up due process is the right to make your case. You've heard, got my day in court. I lost, but I got my day in court. That's why this is so critical, because if you take the underlying protection of all the rights away, the right to a hearing, the right to be heard in a meaningful environment, then you don't have any rights. You don't have freedom of speech. You don't have freedom of religion. You don't have any rights. None of your rights are safe because you don't have the due process to protect them. Yes, sir.
Yeah, I have several questions. I can only ask one?
Well, let's start with let's start with the important one.
Okay. When you were charged, did a judge or anybody ask you if you understood what the charges were?
Probably not.
Okay, one other thing.
See, I went in waived formal arraignment, entered a plea of not guilty. So I didn't. But I'm also, since I waived formal arraignment, I had counsel standing next to me.
Yeah, I'm just wondering. I didn't catch the beginning of your presentation this evening, but did you set it up where you got their oaths of office and jurisprudence and all that, or not? Did you set it up that way?
Did I set what up?
Your
Truth and act.
your
attack his case.
Indictment against your defense.
Oh, no. My defense was based upon the fact that I was innocent. No matter how many oaths somebody takes, and no matter what kind of fringe there is on the flag, I'm either innocent or I'm guilty. Those don't make me guilty or innocent. My defense was based entirely on the fact that I'm innocent. And I would suggest to you that when you start looking into challenging judges or officials on oaths, you may want to do that very guardedly. Focus on the real issue, and the real issue is innocence or guilt. That court is the court. That court is the court, and that judge is the judge. And the flag with the yellow fringe, that's just a decoration. A while back they had one that objected to the yellow fringe flag, and he said, "Well, take it out of the courtroom." He said, "Now, how do you plead?" This is the federal courthouse. This is the federal courtroom, and I'm the federal judge or magistrate, and I'm calling you for arraignment. And I don't care if the flag was upside down, you're still going to answer this charge. Yes, ma'am.
Just a quick question regarding your hung jury comments. I did jury duty several years ago at a local level, okay, and it was a criminal matter. It took us maybe a day or so, and we ended up being a hung jury because some of us felt that the prosecution did not prove its case.
Right.
The defendant may have been guilty, however, we just didn't feel there was enough evidence. We were in the minority, those people. My question is, they retried this person and convicted her.
Yeah.
So unless a person is found innocent, I'm not sure I understand the good of a hung jury when you're going to have to go through it again and
Okay.
again and again.
Okay. A hung jury is not the brass ring, I'll grant you, but it's the next best thing, and it's a whole lot better than third place. Let me tell you a little bit about juries, and you've got more insight in here, more understanding about juries than anybody in the room, me included. But let me tell you about my experience with juries, is that a jury will do its duty as it knows it to be. And one of the things that juries do is they come in there with a misconception that they're coming into that courtroom in order to try this defendant, in order to test him, determine whether he's guilty or innocent, whether he's good or bad, whether he's a criminal or not a criminal. All right, and the first thing that I do with a jury is I remind them that the defendant is innocent, that they are innocent as well, and that there are 13 peers, not 12, and that under our system of government, that the only time the government can come take us away is after it convinces 12, not 1, not 2, not 10, not 11, but 12 of our peers that we should be taken away. What's being tried today, and most of the juries think it's that defendant's fault that they're stuck here on jury duty too, and this is their chance to get even with him. He should have pled guilty. The other thing too is to let the jury know that they are here to try the government, not the case, not the defendant. They're not here to judge him. They're here to judge the government's case and the government's evidence. And if the government doesn't come up with the proof beyond a reasonable doubt all the way over, then they must acquit this defendant because he is still innocent. And that's the way we protect ourselves, not the defendant. That's the way we protect all 13 of us. Because if we lower the bar for this man, where's the bar going to be set if we are the ones then who are the subject of a government accusation? Yes, sir. Who was somebody hit up?
I speak. When prosecution is deciding whether or not to retry a case after it's been the jury's been declared a hung jury, one thing they may take into consideration is whether or not the truth is getting out there, and that all potential jurors in any subsequent trials may now be informed of the rights of the jury, the rights and responsibilities of the jury, like in the William Penn trial, that the jury is judging the law as well as the guilt or innocence of the defendant.
There is ample authority, including Supreme Court authority, for the premise that, or the proposition, that a jury has the right to judge the law as well as the facts. But there is an equal amount of authority that says that the trial court is not required to tell them that they have that right. And now that brings up an odd sort of conflict to me. If I get caught trying to break through somebody's window in their home, and I've got a sack to take my stolen goodies with and tools to break in with, and I get nabbed, that police officer has to tell me what my rights are. But when I go into the courtroom and I'm fixing to stand trial, the jury comes in there. They didn't do anything wrong, but they don't have the right to be told what their rights are. What's wrong with that picture? I've got more rights than that jury does? Just a question in my mind. I get a lot of questions that cross through my mind. I got a strange mind sometimes, and so I get some strange questions.
And that's one of the things that's so important for Liberty Works to inform people too.
That's right, so that I can have the freedom to remain strange.
And the more informed potential jurors there are, the harder it's going to be for the government to railroad people. The smarter we are, the more smart people we are, the harder it's going to be for them.
Benjamin Franklin said, "The man who doesn't know his rights has none," and that was very an appropriate comment on that. But the radio network has the capacity to inform people of their rights. We can't educate people, but we can inform them of their rights. And education's a little bit tougher, but we can at least let them know that they have a right to this, or they have a right to that. And at least then, if they don't exercise their rights out of fear or because they would rather be kept or they like their chains, they've grown fond of them, then at least they're making a knowing determination instead of, not even exercising a choice because they didn't know they had one. Yes, sir.
Is there any, obviously you have not been disbarred yet, is there any talk of that or anything?
When this indictment came out, I received a letter from the bar asking what the status was on this and could I explain this to them. The typical standard procedure in the case of an attorney being indicted is that he is placed on interim suspension. Now, the Bar Association in Louisiana is a little more familiar with me, particularly disciplinary counsel, because we've had a few fights where I've represented other lawyers. I represent a lot of lawyers for some reason. But I wrote them back and told them, look, I have a major front here. I'm guilty of nothing. And I really need to focus my attention on preparing for my defense and defending myself in this case. I would appreciate if you would hold off on any actions to keep from, avoid having to open up a second front for me and distract me from my defense. But I can assure you I have done nothing absolutely wrong. But if the jury comes back and the case is adverse, and you and I both know that things can go awry in this system, we do get it wrong, I'll take whatever action you deem appropriate, which at that point would have been for me to consent to an interim suspension pending appeal. But they didn't do anything. At that point, they just backed off. As soon as I was acquitted, I got a letter from them saying, we have closed this inquiry, and this file is now, this investigation has been terminated. And a few weeks later, I ran into the gentleman on another matter that's heads that counsel up, and he's elated. He's a happy pup. So I can't say what they'll do if something comes up again. I can't say what they'll do in the future. Just who knows.
It's not there now, though, right?
But I think that the bar knows me well enough to know that I am not an unethical man. And I think that might be one of the things that the government might have misjudged when they left an attorney on the jury. They thought that they had such a low opinion of me that the bar certainly shared their opinion. The problem is that isn't my reputation in the bar. And so this guy didn't share that low opinion of me.
Question.
Any others?
Yeah. In many cases, there's a problem in your hearings where the judge moves to sway or influence the jury to think or act in a way that's in opposition to that which is unbeneficial to the defendant, as opposed to the government. What strategies or of approach do you use to overcome those type of encounters, or are there any?
Yeah, that's a common problem, and I'm not going to sit here and tell you that judges are slanted, but I will tell you that trying a case where taxes are involved has a completely different feel to it. What you do is you suffer through the best you can. Whenever we went through my case, I was not permitted to introduce any exhibits whatsoever, not even government writings. So yeah, he was obstructing me. I was not permitted to cite cases by citation. I could make them by name. I was not permitted to read from statutes or cases. Now, fortunately, I was able to remember a few of those things, and I was able to cite them out of memory. Recite cases and statutes from memory. But I've got one of those, the curse of one of those photographic, memories. And so I was able to recite these cases and even name the pages upon which that language was found. And not in my testimony, but I was prepared to do that. And And it showed. I think that the attorney in particular on the case recognized the language that's coming from the Supreme Court, not from me. But I was as restricted as I could be, and I couldn't mention anything. And if I said anything other than me, I was screamed at and yelled at, and it was whoa and hold it, and there's all kinds of whoas and hollering and going on, and it was the judge objected more than the prosecuting attorney did.
Wasn't that a violation of the law on his part?
No, it's his courtroom. And but he can stop the proceeding anytime he wants for any reason he wants. You got to remember, but we never reached that because it never had to go to an appeal, thank goodness. But the thing is that every time we get a blockade, we would back up and take another angle. Okay, and afterwards I dubbed that. And by being a trial lawyer for 35 years, I recognized pretty quick where Larry was coming. And here's another funny little thing about it, is that in front of the witness stand is a screen, and it's a real-time transcript. And as you're saying what you're saying, it's being printed out on the screen at the very same time. So whenever there would be a big interruption and a brouhaha, and the attorneys would go off to the sidebar for a sidebar discussion with the judge, supposed to be out of everybody's hearing. But I'm sitting here watching the screen. And I think they realized that, because after a while the screen went black when they went to sidebar. But I'm sitting here watching the screen. I'm reading the sidebar discussion. So I've got a pretty good idea what the judge is telling Larry. So Larry comes out and he tries something, and based upon what the judge told him, well, what he's doing, I know exactly what to try to do. And so we worked through that. But what you do is, they're no two alike. Tony, they're no two that are the same. And what they do is, it depends too on what's in your case. No two cases are alike. And so what you do is you get in there and you just struggle. And you just fight for a chance to get up there and to make your case, and you do it the best you can. But because we had to go so many different routes, and we had to climb over and go under things and around things and through things in order to get my case to the jury, I told Larry this was the L&M defense. How many people here are old enough to recognize or remember the L&M cigarette commercials? Yeah, they said it couldn't be done. Over, under, around, and through, but L&M did it, So we went over, under, around, and through, and that's what you have to do. It's the same as punching through the red zone on a football field. You do what it takes, and you don't know what the restrictions are going to be. You don't know whether they're going to blitz or they're going to go zone or whatever they're going to do, but you've got to be prepared for it, and you have to push through. And that's what we did. And that's the winner. I mean, that's what makes the difference between winning and losing. And you can't always push through. That's why it's such a bad risk. But we were able to punch and get my story out, even though I wasn't able to show them one single word of law, one single word of a case, and even though the government or the judge allowed the government to put up copies of cases and statutes it was going to hit me with, and to show those to the jury. That was okay on cross-examination of me, but it wasn't okay for me to show them the very same statute. The mistake that he made was when he put those up there, it just gave me an opportunity to say, see what I was talking about? There it is. And so, did I answer your question? Okay, thank you. Yes, sir, Troy?
You mentioned about you're filing a criminal charges against them for letting people know that you were actually under a criminal investigation. Are they not to disclose that at all?
You mean on the grand jury?
No, just if you're under a criminal investigation.
No, they're not to disclose that at all. The only
to
time
anybody. I mean, you say about letters going out. What letters were you talking about?
Circular letters that go out they went out to all my clients and friends. They even went out to my dry cleaners.
So those letters that go out and say they're trying to find out information about Tommy Cryer. He's under a criminal investigation. We want to know this, and that. That's illegal?
Yeah, that in that form, that is illegal. Particularly in the Fifth Circuit where I am, because the Fifth Circuit has said we're not going to go for that. Now, the Fifth Circuit has allowed people to identify themselves in a personal interview as being from Criminal Investigation Division, the CID, because they've got to show their credentials, they've got to identify themselves. But on letters, circular letters they call them, form letters that go, they said there's no reason to disclose that. You only can disclose information about a taxpayer if it's necessary in order to obtain or verify the information it sought. If it's not necessary to do it, then you're not allowed to do it. And so now, whether I don't have a right to make these people prosecute them, all I can do is bring it to their attention. Just like you can call the police and say, "Well, I want so and so arrested," but you can't make them arrest them. But I made the charges known to them, and I made them known to just about everybody under the sun, and it's got to be a major embarrassment. And as a result of that, they have the budget bill that was just filed has buried in the budget bill a provision altering the law to allow them to state the nature of the investigation to people, whether it's necessary or not. So they're trying to rip the stitches out before I can get them in. They but it was a direct result of my having made those criminal charges and my having filed that suit. They have put it buried in the budget bill, just, shuffled in and slipped in between some pages. They also slipped in a provision that says that multiple failure to file 3 years successive will be treated as a felony. The Treasury Department put that in. Bush doesn't get to do anything more than I do. He's a figurehead. You know where the power is. It's the Fed. And owners of the Fed.
One other thing you were going to talk about, we talked to you earlier there about you were going to bring some kind of a book or something. You had all the information on cases and everything.
Oh, I was going to tell the story of the notorious notebook, and I didn't do it. All right, well, gather around, boys and girls. The story of the notorious notebook. At the end of my testimony, it was apparent that I had an impact on this jury. Okay, the courtroom was just electric. People described it; they could feel it. Their hair was standing up. The judge obviously was not a happy camper. This judge hated my guts. He detested me.
Why would that be?
Because I am one of two things. Yeah, well, I don't have to have a judge like me. I have won cases before judges that didn't, and I've lost cases before judges that did. I don't care if he likes me or not. I just want a fair hearing. And when it came down to it, and I'm going to be fair with that man, just as I'll try to be with everybody. When it came down to it, he gave me a fair hearing. He interrupted a lot. He didn't make it easy. But whenever it came to the jury charges, I got the jury charges I should have gotten. And when it came to getting evidence in that he was telling me he wasn't going to let me get in, I managed to get it through past him anyway. He allowed me to have a hearing. When it came down nitty gritty, when he was threatening to do things that were really totally off the wall, he was threatening to hold 2 trials, a deposition of my views, and then he would be the filter, the gatekeeper, he called himself, where he would decide which of those opinions and beliefs I would be allowed to tell the jury about and which of those that I would not. Well, this is what he was threatening to do. This is what he wanted to do, and you could tell he wanted to do it so bad he could taste it. Like hold a deposition of the defendant to see what his testimony is before, and didn't go back in and tell the jury. But he didn't do that. When it came down to brass tacks, he did the right thing. He gave me the right charges, and I've got no axe to grind with that gentleman. But he did hate me, and he did comment, and he did make it tough. But the Notorious Notebook is part of that story. I had a notebook consisting of the materials upon which the main ones, materials, and it consisted of 2 volumes, 2 6-inch volumes of binders, and that was too much. And I was ended up during my rehearsals. I was flipping through pages too many times So what I did was I went back and I took each one of those and I just yanked out the pages that were highlighted or that were very just key to my case, and I left the rest of all that stuff out. And I tabbed them, I had them lined up and in order based upon my outline. In there also I had a chart on what I called R2 cases, where they say that these cases hold that wages are to income, and you look at them and it doesn't hold that. None of them hold that. So I had all of that along with the antidote and the whole 9 yards and the truth about the case charted. I had 3 charts in there. One chart was a chart that showed the scope of the income tax law, color coded, what's out of it, what's in it, what's excluded. Okay. I had another chart that went on with the jurisdiction of Congress. And I had a green, yellow, and red zone there too. And another chart that had what is the taxing authority of Congress. And I had a green, yellow, and red zone there too. And if you take them and you line them up, you look at all 3. I never got to show those to the jury. But if you look at them, they're all identical. Well, what a coincidence. You know, and we're all in the red zone. We're all down here on jurisdiction. We're all down here on taxing authority. We're all down here on the income tax law. What's to disagree with? Everything agrees on this end. The only disagreement's with the Internal Revenue Service. So I had all of this stuff that was really the condensed down version of the notorious notebook, my trial book. I also had in there my outline that Larry had and that I had, and George had one of, in front of him. And he used that as a guide and a checklist in my examination. And at the back end of that outline was a listing of reserved for cross. 1, 2, 3, 4, 5 points that I knew they were going to come at me with because of discovery. 5 points, 1, 2, 3, 4, 5. And I had it marked as reserved for cross. Now, when you've got something bad, or you've got a point they can make, or something that they can score, you bring it up. You don't wait for them to bring it up, because it looks like you left out something. You know, they caught you on one, right? So you always bring it up. So why didn't I bring those 5 up? Because under every one of those 5, the government only does half a job half the time. The other half the time, it doesn't do half. And they had these 5 things they were going to come after me on. Every one of them had a big, big fault in it. There was a trapdoor under every one. Well, this young attorney, I'd say young, he was 30 or 40, he'd had enough experience to know I would not have reserved those points for cross if I didn't have a trapdoor under each and every one of them. So he did not come at me with one single one of those points. He just scratched them completely. And what should have been a 2-hour cross-examination was over in 15 minutes. And he never laid a glove on me. Now, how did he know to stay away from those 5 things? At the end of my testimony, the judge is not happy. He said, Mr. Cryer has this book in front of him. He's been there all day, and all day the day before. This book in front of him, what's in there? And, his trial notes, Your Honor. Well, I'm going to order those, handed up to me for me to view in camera to determine if those are discoverable material. It was all law. Law's not discoverable. Facts and evidence are discoverable. It's all law. So I said, sure. I handed it up and carried it over there. And the judge is flipping through this, and he's seeing nothing but the raw, uncut, boiled down to the white powder in the bottom of the pot truth. And the farther he went through it, the more sick he looked. Because what he was seeing was, he was seeing cases and quotes that he had just heard me testify to verbatim. And he knew, you could just tell he wasn't feeling good. So he said, well, I'm holding that this is discoverable. It's law. Supreme Court cases are discoverable. Statutes are discoverable. I'm holding this as discoverable. The problem was the government had moved for discovery. So he moved. He said, you're entitled to see it's on discovery. You want to move for discovery? Oh yeah, Your Honor. I want to move. So he says, I'm ordering you to turn that book over to the assistant U.S. attorney to have him study it overnight before he cross-examines Mr. Cryer tomorrow morning. And you know what Larry said? Glad to you. He looked over at me, and I winked. You know, this eye is away from the jury, it's away from the judge. And I winked, and he looked at me, and he could tell, I don't know if any of you know Larry, but he's little Abner. You know, he can't hide anything, you know. And if he's got a grin in there, it's coming out. And you can see he was just twitching. He's just trying, like the Nick used to look very serious and sober. And he says, "Of course, Your Honor, we have absolutely no objection." And he hands this book over to him, like so. And the guy takes it, and it looks like he's wondering if it's ticking. You know, and he takes it back and puts it on his table. And then we broke for the day. The next morning is whenever the AUSA came out after having studied or looked at the notorious notebook, seen the outline, and seen that I had 5 traps waiting for him on cross. And it was a wonderful thing. Now, what the notorious notebook is that somebody wanted us to post a transcript of the trial on the website, on Truth Attack. Not a bad idea. Let people see how you testify, and one way of doing it. Everybody has a different story. Everybody has a different way of saying things. But yeah, let's put it up there. But it's $1,600. We don't have $1,600. I'm still trying to figure out how to pay last month's rent at this point. You know, don't have 60. Well, somebody emails in said, "Hey, I heard the story about the notorious notebook. You know, what if you were to offer that notorious notebook on CD for a $50 contribution? All you'd have to do is get 16 people, and 32 people, and you'd have your $1,600. Well, I said, that's an excellent idea. So we did that. We put the word out that, we're offering the notorious notebook as a gift of appreciation. We don't sell anything on Truth Tech. Gift of appreciation. And for a $50 contribution or better. And it took us about a month or month and a half, but out of that $1,600 with the CD, we raised $7,000 of it, which was half of what we raised all of last year. We raised $7,000 out of the $1,600 with that notorious notebook. And it's what it also has on there, though, is it's got the full text. Remember I said it had the big volumes, all the text? It's got the full text also in there, under the full text folder. But it's got the notorious notebook just as it is. The outline is there, and it's thumbnailed or bookmarked or whatever you call it, where you click on that number, and it takes you to that document that has that number on it. And it's a good little tool. We got some other research stuff on there in the videos from YouTube. And what we also do is offer for the same thing, same deal, $50 or better contribution, a CD with Larry B. Craft searchable codes and regs. And what we got now going is because our store software is all wrecked up, not working well, we can't tell what somebody's doing. What we've decided to do is that for a $50 or better contribution, we're going to send both of them to people until we get the new website where the store's working. But that's the story of the notorious notebook. Is that, did that answer the Bill Choi on the story of the notorious notebook? And it was kind of funny. Yes, sir.
Did I hear you say? Did I hear you say that you have the agents had to go back and sign what they had done and so forth, and you got a copy of all that?
What I have copies of.
How'd you get a copy of that?
Okay, in discovery, I was provided with copies of the interviews, memorandums of interview, and the copy of the correspondence where they would write notes on the letter and send it back to them. These inquiry or circular letters. And so what they would do is, so that's how I got the copies. But what they would do is they'd go out and meet with somebody, then they'd go back to the office and they would memorialize it in a memorandum of interview called an MOI. Then they would sign the memorandum of interview and file it.
Have you got a copy of that?
Yeah. You know, that's a good thing. And any others? Yes, sir.
If the federal government can get by with muzzling John Kottmeyer, is it not but a small step to go after preachers who are still preaching the Bible in their pulpits to use the same process to silence them?
Right now, the federal government. Now, you're right. Your question is, the answer is yes. I'm not sure, though. Right now, the government has a sort of ambivalent approach to the churches and the pulpit. On the one hand, they're trying to get ministers through 501c3 leashes that have these government leashes on them the same way as a government leash on your state legislature, to step in and encourage the people to submit to martial law. That's just happened. That story broke in Shreveport, my town where I live. About 6 or 8 months, no, about a year ago. WorldNet Daily broke the story. On the other hand, the government would love to have the churches out of the picture, because the idea behind the press of all of these things that are happening to us, all the things that they are doing, is that, in my opinion, I'm not telling you fact here, I'm just giving you my opinion, and I think it's correct. The object is to eliminate natural law. Now, natural law is a law of nature, the law of nature's God, unquote, from the Declaration of Independence. Natural law says that you get your rights from your Creator, not from the Constitution. Okay, by eliminating natural law, by eliminating God from the picture, then the only rights that you have are the rights that they decide you have. And what rights you do have are thanks to them, not to somebody else. And that would make you totally dependent, totally at their mercy. So I don't know which way they're going to go. They want to use the church, and yet at the same time they don't want what's behind the church to exist anymore. It's sort of I think they're just playing both ends against the middle. But a lot of this stuff doesn't happen because it's been well planned. A lot of stuff the government does happens because it's merely the nature of government to grow at the expense of liberty. I know every one of you has heard that from Thomas Jefferson. But that is the nature of government. And it will grow just like a cancer tumor doesn't grow according to a particular design, because it's an anomaly from design. It's a departure. Well, the government's just going to grow where it can, as it can, and it's going to progress like a cancer until freedom is choked out. And but it's just because it's the nature of the beast. How many people know the story of the frog and the scorpion? All right, is that what government's like? For the rest of you, because I'm not going to do that to you, the scorpion wanted to get across this river, and the frog was swimming by, and he said, "Frog said, how about giving me a lift across the river?" And the frog says, "Oh no, man, I'm not going to get around you. You're a scorpion. You sting me." And the scorpion says, "Wait a minute. If I sting you, you'll drown, and then I'll drown. So I can't sting you. Wouldn't make any sense for me to sting you, would it?" So the frog says, "Well, I guess that makes sense. Sure, I'll hop on my back." So he's swimming the scorpion across the river, and they get out in the middle of the river, and the scorpion stings him. And he says, "Now you've killed us both." He said, "So, why did you do that?" And the scorpion said, "Because I'm a scorpion." So when you say, why does the government do this? Why do they keep expanding their power, and why are they assaulting our liberty? What do we ever do to them to make them want to take our freedom away? What do we ever do to them to make us want to gag citizens, or to restrict freedom or rights, or to disrespect our ownership of our own labor? What did we ever do to invite that? We didn't. Well, what do they expect to gain? Well, it doesn't matter. Well, why did you do that? Because I'm a government. It's the nature of the beast. Now, in this case, it's driven and accelerated by the fact that there are people who benefit from having a powerful totalitarian government. Those are the rulers. Anybody here going to be one among that group? If you are, take us with you. If not, then we all lose if this thing doesn't get turned around, because we're not going to be among that ruling class. Yes, sir.
This is a warning I give people all the time who have, especially people who put bumper stickers on their car, really wanting a cause, gun control, as a for instance. And I'll say, when you get your dream, you've empowered the government to do something it doesn't have a right to do, and it can use that right against you as soon as it's got it. Once you no longer have your gun, or abortion. Once it has, the government has seized the right to kill somebody who's innocent, nobody's rights are protected. So beware of what you're empowering the government to do. If you're a liberal and you're trying to get a liberally and empowered government on your side, that government, that scorpion, will do what the scorpion's got to do.
Right. And basically, if you look back in Gerald Ford, and this was before he bumped his head, he was quoting somebody, and someone I imagine will be able to tell me who this originated with, but said that any government that's big enough to give you everything you want is big enough to take everything you have. And they know that. And the problem is that everything that they take from us, they give us some sort of little benefit back, like you're giving a kid a peppermint stick because you took his his savings, which is what Social Security is. We're saving up for your college, so half of everything you get for Christmas or for grades or whatnot, we're sticking in this piggy bank. And when you turn 18, we're going to turn it over to you, and you're going to have your college money. And he opens it up, and all it is a bunch of IOUs. Thanks for the money, Mom and Dad. We borrowed it, We'll pay you back one of these days. And notes. We'll give you more promises on paper. So, but that's what you're absolutely right. Everything that you get, there's a price for. And the best thing to do is to get the government just out of your life. Leave me alone. Stay away. I don't want anything to do. Most of us should never have any contact with the federal government except for to go mail something or to serve in time of war.
And that was the intention of the framers.
That was it.
That we were insulated by the states and the counties.
Well, the states, which are now dead because of the 17th and a bunch of other reasons, they were practically dead. 17th was a coup de grace. It was a mercy blow.
Making senators electable at large.
Well, taking the Senate away from the states. See, the original intent was that the states had a house and the people had a house. And that way, since it took both houses to pass a law, there would be no law that the states could ever be subjected to which they had not consented. And there would be no law that the people would be subjected to which they had not also consented. And so we're talking about government by consent. The only problem now is that the states don't have a house anymore. And the Senate, which is totally indifferent as to the people, has its own agenda, and it's going off its own way, and it's representing its party, the Republican Party. The I got mine and I'm in and you're out, too bad party. The only difference between the two of them is that one wants to drive it off. It's just arguing over who gets to drive the bus over the cliff. Me too, me, no, me. So I think I'd be looking at a map or something. But Ron Paul.
Marvin, you have a question?
Yes, I was wondering where the government hid the regulation 1.1-1. It's not in there. Where
Look.
Where did they put it now?
Where's my tinfoil hat? It comes out of the air. There is no statutory basis for 1.1-1. There is absolutely no statutory basis. But I'll tell you another one. Go a little deeper. Take 1.1-1. Go down to the separation or the designation of legislative regulations. When you go down the list of all regulations, then you go down past that, there's another little table of contents like thing. Get down to that. And those tell you the difference between what is called an interpretive regulation, what's called a legislative regulation. A legislative regulation imposes a duty on you. It says you've got to do something. Or it imposes a prohibition against you. It says, don't do that. Or it says, this means you've got to do this, or this means you should do that. Okay? The ones that aren't on that list are called interpretive. That don't mean that you got to do anything. They're not binding at all. They don't create a duty. They don't establish a liability. They don't identify anything as income or not income, and they don't say what is or isn't taxable. They are nothing weight other than that, and the Secretary saying, in my opinion, Section 1 means this. So it's just out of the air. They've just made it up. It's as much a law as a letter to the editor. That's as binding as a letter to the editor. You won't find it among the substantive regs. You will only find it among, so it's among the interpretive regs. And interpretive regs create no duty. They have no legal effect. And I could go into another area on that, but I won't. We've covered a lot of ground and we've gone a long time. But
in the regs, though, for a certain number of years, then all of a sudden it disappeared. I forget what year it was. It was not in there anymore.
It's propaganda.
Already, it was always propaganda from the beginning, right?
It's an opinion,
right?
And it's an opinion without a basis.
Mm-hmm.
Yes, sir.
Since Save a Patriot's been gagged about dealing with anything with the IRS, is that something that truthattack.org is going to try to help take up the cause for that, and with people trying to deal with the...
Okay, truthattack.org. Are you a lawyer? No. Okay. Well, you just set up, I can just see the guillotine coming up, where you were jacking that blade up. And setting up a cross-examination point, because that would be a question I would use to set up for a perfect kill. But I'm not going to stick my head in there. All right. Truth Attack does not operate under the direction, it operates totally independently of all and each of the sponsoring groups. It is totally independent of them. It is operating with the grace of their support and best wishes, and they are supporting and encouraging and facilitating as an auxiliary any way that they can. But it's not...
My question
Truth Attack is not going to speak for Save a Patriot.
Question. That's why I see why you're worried. Is that kind of a service? If I needed to have help with dealing with the IRS, could I approach truthattack.org to get that service?
Oh, okay. That's an easier question.
Okay, I'm sorry. I should have asked it like that first.
Oh, okay. I mean, that was a nice trapdoor, though. You did it well. If you weren't meaning to, you certainly did a good job of it. And I don't know if I can explain why that was a dangerous trapdoor, but it was. No.
No, okay.
No. Truth Attack is extremely careful to make no recommendations, to provide no services, okay, relative to any method, means, or any dispute, or how to write a letter, other than a letter to the editor or a letter to your congressman. But as far as how to write a letter to the IRS or to respond to a summons, or how to respond to an illegal levy, we are going to educate people as to how they can get an attorney somewhere to get, when it's time to go see a lawyer. For example, with our disclosure on 7431 suits, it'll be a questionnaire there. It says, have you, in the last 2 years, been the subject of an audit, examination, or investigation? All right. If during the course of that, have third parties been contacted? All right, were third parties contacted by mail, by personal interview, by telephone? You know, during those, did this happen? Or did this happen? Or did this happen? If you don't know, you'll click here, go to a FOIA form you can pull down and find out if anybody's been making contact with third parties about you. But if so, and it's been within the last 2 years, and if, you know, they disclosed this, this, and this, or this, this, and this, then you may be entitled to compensation. You need to contact your attorney. Reason that we do not, and we're very careful not to, is not that we don't want to help, but that we don't want to be characterized as having provided any, quote, tax shelter. Write a letter saying, you know, I'll be there for the summons. Here's your form letter. Oh, there's a tax shelter. Got to shut Truth Tech down. Got to tell Tom Cryer to shut his mouth. Quit telling people the truth some more. We're doing that to protect the message. But we have posted on the website a host of sponsoring groups that do provide those kinds of services. As far as we know, reputable. We had one on there that is not there. I'm not going to name any names, but I mean, there was one that I didn't approve of. I didn't feel that they were up to the Truth Tech standards, and they're no longer there. But the ones that are there seem to appear to do a good job. Yes, sir.
When an IRS agent says that they are above the law, whenever there is a search warrant, what do we think of that? Do we accept that? Do we say nothing about that?
They don't start shooting. Yeah, a lot like Gordon Liddy, he says, no, they've got body armor. Go for a headshot, you know. Don't do that. Don't do that. You don't, you know, I don't know what to tell you can do with that other than sit there with your mouth open and wondering, what's become of my country? What have you done with my America? What have you done to my country? Where is it? Bring it back. I want it now. I'm like Alan Keyes. You know, where's my liberty? I want it back. I want it back right now. You know, have anybody seen that guy get it down and get funky? I'll tell you what, he could have him jumping up and down a chair. What a man. He and Ron Paul for president and vice president. Yeah, I wouldn't care which order it was. We'd be okay.